Only contract parties may demand or owe performance unless one party assigns its rights or delegates its duties to a non-party. But sometimes assignment and delegation aren't permissible, as explained in Crane Ice Cream Company versus Terminal Heating and Freezing Company. William Frederick owned and operated a small ice cream making business in Baltimore, Maryland. He entered into a 3-year requirements contract with Terminal Heating and Freezing Company, under which Terminal agreed to supply Frederick with all the ice he needed for his business at a fixed price, up to 250 tons each week. Terminal also agreed to receive payment the week after each delivery based on its weight as measured by Frederick at his loading dock. In return, Frederick agreed to buy ice exclusively from Terminal, except for any amount he required that exceeded the weekly 250-ton maximum. But if Frederick didn't need ice at all in a given week, he didn't have to buy any. Both parties faithfully executed the agreement, and shortly before the end of the 3-year contract period, they renewed the agreement for another 3 years. Soon after that, Frederick sold his business to Crane Ice Cream Company, a large corporation doing business throughout Pennsylvania and Maryland. As part of that transaction, and without Terminal's consent, Frederick assigned his rights and delegated his duties under the contract with Terminal to Crane. After learning about this arrangement, Terminal refused to supply any ice to Crane. So Crane sued Terminal for contract breach. Terminal moved for dismissal, arguing that the assignment and delegation were unenforceable. The trial court agreed with Terminal and dismissed the case. Crane appealed to the Maryland Court of Appeals.